Stanley Nyiringita. It's one of that day that we discuss matters law and give you some legal tips. And today we're asking you, do you think children born outside of a marriage union should inherit property of their parents, one of the parents? And well, this might be affecting you. I mean, as you listen to this, it might be affecting you either directly or indirectly. And you probably know someone who is involved in all this legal battles of they're probably born outside of that marriage union. Maybe the dad or maybe even the mom isn't the biological parent. And they're involved in all this legal battles, just trying to see if they can inherit property. So what do you think? Have you been in that situation? How did you handle all that? And how did it pan out? 0795-045-864 is our number. It will be displaying pale chini kwa screen yako, the bottom of your screen. You can write that number down, 0795-045-864, and call us live and tell us what do you think about that bit. You can also text us on our numbers at 22047, so our SMS number. When you go to our Facebook page at TV47KE, we've posted that question for you. Do you think children born outside of a marriage union should inherit property of their parents? Quite a sticky issue that we'll be trying to analyze right here. And to help us understand this conversation is a gentleman who has been here before, just spewing wise wisdom for us. Silas Akiro, lawyer Silas Akiro, karibu sana.
Thank you so much.
Good to have you once more.
I really appreciate Stanley for being with you once again.
And I hope your morning is fantastic.
Yeah, exactly. My morning is very good.
Right. So even as we talk about, because here, even non-biological, just understanding what the law says, because there is also a word that is commonly used, out of wedlock, children born out of wedlock. So help us understand what the law defines non-biological children and children born out of wedlock and all that bit.
Now, Stanley, when we look at the law on children, we are focusing on three basic laws. The first one being the Constitution of Kenya, 2010. The second being the Children's Act, 2022. And the third being the Law of Succession Act. But when we mention particularly on inheritance, then our focus is geared towards the Law of Succession Act. Now, at Section 3 of the Law of Succession, there is the interpretation and definition of different terms or categories used within the Act. When you look at the definition of a child as per the Law of Succession Act, then will be the children born or those that have been taken in and recognized and or accepted by the man or the parent as being his own, whether or not biological. Now, when you look at the definition of the word wedlock, though not particularly from the law, but from the wider perspective, it is believed that once you get married, Stanley, you have locked out others from this union. We normally call it the union of just but one man and one woman to the exclusion of others. So if a child is born outside this lock, then we come up with the term born outside wedlock. So they are particularly not your biological children, but if you recognize them as your children, take them in. Maybe the woman came with them, the man came with them, you recognize and take them in as forming part of your children, then they are also within the meaning of dependents or a child as per the Law of Succession Act.
As a parent, you have to formally say that I take this child as my, I take this boy or girl as my child, and you have to go to court and actually say it and formalize it? Or before the court, do you have to prove that I have lived with this child for this amount of years, I have paid the school fees, I have catered for their basic needs, so that is how I actually agreed to be the parent? How do you, or is it just sawa kuja tu tuishi?
Stanley, we have to stay clear the path that by the time the child is defined in court as being a child of the deceased, it means you are dead. You are not there to explain to the court that I took this child. So it is upon the living to confirm to the court that this child was taken in by the deceased, and this child was recognized by the deceased, and this child was the child of the deceased as he knew it, and then that this child is therefore forms part of the survivors of the deceased person. And whatever estate that remains of the deceased, then this child will be viable to also be given a share if the deceased died without leaving a will. But if the deceased died leaving a will and does not include this child, it will be a long road for him or her to be able to get a share of the deceased estate.
Right, fantastic.
Yes.
A nice introduction of the same. So let me take you to last year, November, where the Court of Appeal proclaimed that any child born out of wedlock is entitled to benefit from the wealth left behind by the deceased parents. So this is last year, November. So that means before this proclamation, maybe things were done differently, you'll tell us. But then, so what kind of effect does that have? Because over the years, 10 years now, and we've been seeing proclamations by different high courts in different regions, just having hallmark judgments and trying to interpret some of this, the Matrimonial Property Act, the Article 45, Article 53, Article 27, just trying to interpret them in different kind of cases. A good example, the matter of Peter Mburu Echaria and Priscilla Njeri Echaria, and just to mention a number of them. So first of all, or the same, what do you make of, so for someone, a child born out of wedlock, even before, so a case that was maybe ruled before this, November last year, how does now the court interpret that, that was ruled before that?
Well, in law, Stanley, we have things known as judicial precedences. We may have a long-standing precedence that has not been overruled. But once a court of that standing, we are talking about the Supreme Court, whether there were 100 decisions before this decision of the Supreme Court of last year, they all stand quashed, they all stand unapplicable. And so the precedence that is on operation within this matter is the immediate precedence by the Supreme Court of Kenya. Now, on a light note, Stanley, when you look at the way this law came about, the issue of children born out of wedlock being viable to also inherit from their adoptive, let me call them adoptive parents' estates, it's because this child has a biological parent, whether father or mother, depending on whom you've taken in, who has come with them.
Yeah.
Then you have denied them an opportunity to look for their biological parent. And you have created a legitimate expectation that for whatever responsibility they may require in their day-to-day pushing of life, they should be coming to you. And then at the end of it, you now want to turn against them. The law said that that is not the law of natural justice. The law of natural justice requires that justice be done. There should be reasonableness, fairness, and justifiability of every action. So the moment you create a legitimate expectation to me that you are my parent, then you should be able to create, to make up for that legitimate expectation. Because had you refused earlier, I would have looked for my biological parent, or I would have made the life's end meet for me as the struggle for the fittest would put me. But now you have absorbed me in, and you see, when you talk about succession, we are looking at dependence, particularly for children. We are looking at dependence. Even your own parent, you are dead, but then your own parent cannot easily inherit from your estates until they prove dependence. The only persons who must not prove dependence are your wife, your wives, former wife or former wives, and children. And children here
the biological
includes
all of them.
Includes those born out of wedlock. Remember, as at section 29 that provides for dependence, section 29 of the Law of Succession Act, it talks about children. And then now you have to go back to section 3 and read the definition of who is a child. And then you realize that section 3 informs you that when you're describing a child as per section 29, then you need to define this child as described by section 3, which includes children brought in, whether born or not, but recognized by the deceased as his own.
Wakili, you've told us that the wives do not have to prove dependency, but do they have to prove that they helped in one or another acquire this property or even build it? I'm asking this because the case that I had mentioned, which is in public domain, the matter of Peter Mburu Echaria and Priscilla Njeri Echaria. So the court was trying to interpret this and holding that equality of spouses doesn't involve redistribution of property rights at dissolution of marriage. It also quotes that where disputed property isn't registered in joint names of parties to marriage, but is registered in the name of one spouse, the beneficiary the beneficiaries of each spouse will ultimately depend on their proven respective financial contributions, either directly or indirectly in acquisition of property. So basically, just to summarize all that jargon, this is the court saying that you really have to prove and give evidence and bring us documents that you helped acquire this matrimonial property.
Good. Stanley, remember, when we are talking about inheritance, we are talking about one spouse dead and his estate has to be distributed. But when you're talking about the share of matrimonial property, we are now discussing dissolution of marriage.
So what? So now, just to now bring into that.
Good.
So what's the effect of now the child? So hypothetical of. Let me give you now hypothetical some names that are very common here. So you do have Brian, you do have Mary. So Brian is, let's say, the deceased husband, and then you do have Mary. So Mary, let's say, had, or maybe even Brian had children born out of wedlock out there, and then there's Mary. So maybe these children, let's introduce someone else. Let's say Jane, who's the mother to the children born out of wedlock with Brian. And they're trying to also acquire the property that Brian, who's the deceased, left. Does the court have to tell the mother of these children to prove that she also helped acquire this property or even maybe manage it for these children now to inherit them?
Well, remember, when you are inheriting the deceased person's estate, you are not obliged by law to prove contribution. You are only obliged by law to prove the degree of dependence.
Okay.
And if you fall within the confines of Section 29 of the Law of Succession Act, particularly subsections A, B, and C.
All right.
But then now when we discuss, I think your question is best answered when you're talking about dissolution of marriage.
Okay.
Yes. Because at inheritance, so long as you can prove that you are a child of the deceased, whether or not born by the born by the deceased, then you are viable to inherit from the deceased person's estate. But then now when we come to dissolution of marriage, where a matrimonial property act comes into play.
Now used. Yes. And even as you continue, because so last year even the Court of Appeal was saying that when it was giving the whole pronunciation of children born out of wedlock and why they should acquire and inherit the property of their deceased parents, and saying that, well, the rights of children must be distinguished from marital status.
Exactly. Because I told you in the beginning that you have taken in this child, created a legitimate expectation that for his needs in the society, he needs to come to you. And then there is no way the law will allow you to make away with a vile or a wrong in the society, where if now it comes to the distribution of your estate, you lock them out. You see, that is basically you are infringing on the child's rights. You have actually interfered with the link between the child and the parents. Because remember, I told you that if you did not want them to inherit from you, you are at liberty to instruct the biological parent whom you have, maybe the mother or the father, that these children may look for their biological father or mother. But now that you have taken them in and you have put that interconnection, that link, that I am your father, there is no way the law will allow you to refuse them inheritance. So when it comes to now sharing their parents' property, particularly at dissolution, where the matrimonial property comes into play. Remember, today, you are not being entitled to a half of what the man or the woman has, but you're being entitled to a half your contribution. What you have, both of you together. You see, Stanley,
Right.
Yes. So if you were married into this home and you found that the man has all the cars, has all the houses, has all the land, has everything. The only thing you will be entitled to is 50% or probably the improvements you have made in these things.
Right.
That is the only thing that the law will give you as a woman or as a man. But then when it comes to the children, their right to parental responsibility continues, whether or not they're your biological children.
Right. And even before I get into the next one, because now, even as you continue, someone will ask, now, what about the will? But before you give us that, remember, you can always be part of this conversation. On Facebook, when you go to our Facebook page, TV47KE, we have a poll there. Should children born outside of a marriage union inherit property of their parents? And there's the yes, no, and I don't know. The yes seems to be quite a number of them. When we wrap it up, we'll be seeing how many. But then there are also a number of comments. Let me take a look at them, and also some questions that people have posted. Taragon says, if I am their father, then they must, though a good father will always invest for them outside those marriage. Legacy, okay. I'll have to skip that one. Philip Mwainge, the birth certificates have the full names of both parents, even the ID numbers. A final one, I'll be taking a look at others later. What is outside when they are part if one's lineage by blood? Okay. And Omorai Lucas wants to know which parents, the outside ones or inside? Yes, but then a couple of them are saying yes. Jackson Karika says yes, children are innocent. And I mean, definitely, even the law really stipulates that, well, these children are innocent, really having, and even actually, Article 53 tells us every child has a right to be protected from abuse and all that.
Actually, that is the part of the Constitution I was talking about.
Yes. So now, if the law is telling us this, with the failure of this child, and again, back to my hypothetical, let's say if it's Brian, before his demise, he did not have a will. That's, let's say, scenario one. He did not have a will that really showed that this is what I'll have to separate for my children. What happens in that case, even for the children born out of maybe wedlock, or actually, let's say, children that are actually maybe not his, that would want, or maybe even the wife came in with other children, and these children also want to inherit this property just by the virtue of they recognize Brian as the father. Or scenario two, he had scribbled down a will, but left out the non-biological children. What happens in some of the scenarios?
Now, Stanley, when we talk about succession, particularly in the world, not in Kenya alone, it is undertaken in two forms. One of them is called probate, where a will is left, and the other one is intestate succession, where there is no will left. Now, where a will is left, then the validity of the will has to be put into question. And some of the things that invalidates a will, it was done out of duress, coercion, forceful, and maybe it was not attested by persons of independence, and probably it left out dependents. Some dependents who were supposed to also do what? Inherit. As such, the law will not allow that will to pass, having too well known that there are few others that have been left out in this will. And so, in such scenarios, there's a will. These children have been declared children as by the law, and then you leave them out, then that will have to be knocked out, and then intestacy will come into play. Now, you see, everything we do at private has to be in conformity with the law. And where whatever you have done is against or contravenes the provisions of a constitutional legislation, then that item you have, or the will you have, is considered unlawful or illegal or irregularly done or procured. And so this goes to our parents out there who maybe they want to do wills. Make sure that the will conforms to the law. It may be not in line with what you want, but it has to conform to the written down law. Now, when it comes to the father now did not leave a will. We have children born out of wedlock. If there is no will left, then all the dependents have to be included in this succession. In fact, there are 6 forms that are always supposed to be filled out when you are petitioning for succession of the deceased person's estate. And one particular form, which is always very significant, is form number 38, P&A 38, which is consent of persons of equal or lesser priority. This is where these children come in. They are also dependents of the deceased person's estate. They were depending on it. And by being dependents here, they have equal priority or lesser priority to whoever is petitioning to be given a grant of letters of administration interstate.
Right.
And so after all the assets have been gathered and collected, the law first of all allows the family to sit down and discuss that the total estate is 46 acres. We are 10. Let each person take 4.6. If there is a disagreement in this, then we go back to court. The administrator will say that the family sat and this is how they discussed. Then the objector, including the child born out of wedlock, can now object and say, no, this is not how the family agreed. Then the court will disregard the share formula taken by the administrator, and the court will adhere to the provisions of the law as pertaining intestacy. And that means that each and every person will have equal, not equitable, but equal share of the deceased person's estate, including those children born out of wedlock.
All right. Yafesi Bigi Amwai seems to agree with this. He says they should inherit from the biological father and only from the foster father if he voluntarily included them in his will. We've seen prominent figures who pass away, and in the funeral service, a lady is present, and she is with maybe a daughter or son. And she claims, well, huyu mtoto ni wa huyu mzee mwenye ameenda. And so, because you also tell us that, so it has to conform, whatever is done in private and all this, has to conform with the law. But then we understand that there's a Sharia law, what, the Islamic faith and, the Muslims would really follow. There's also the interplay with the customary laws, where, different communities would really have even their own laws. So, is there a gap in when, let's say, for example, now in such a case, again, kama hiyo, let's say, Akina Brian and the hypothetical that I'd raised earlier, in such a scenario where the man passes away, and let's say, for example, the man was of Islamic faith and the wife is a Christian, and maybe, the children born out of wedlock in this are, let's say, from both, and they're really trying to push that we acquire our father's property, who is Muslim. How does that play? Or rather, even in some of these communities that largely, for example, the Gikuyu, some of them would say, no, we do not recognize this person because maybe they're not circumcised here, and other kinds of maybe excuses that they would have according to their own customary laws. How does the law play into that when customary laws as well as Sharia law is involved?
No, Stanley, the Constitution provides that customary law that is inconsistent with the Constitution is unlawful. So even the customary laws have to be consistent with the law.
Okay.
If there is a customary law that is disinheriting a legitimate child,
it's unlawful.
That will be declared unlawful.
All right.
And that is why even the decisions of customary law always end up to a finality in a court of law. But now in a court of law, the court of law has to pass your customs in the mirror of the written law. Now if on a balance of the written law, your customary laws weigh lesser or lower, then your customary laws will be knocked out. And so in your hypothetical scenario, we have a father who is a Muslim and a mother who is a Christian. Although, of course, maybe divorce has taken place because in a real life situation, they will always not be together because the Muslim will say once the wife has turned to Christian, amekuwa kafir, and so will be knocked out.
Right.
Or if the Muslim is marrying this Christian knowingly, then you see in their law they say that the Christian has to convert to Islam. So assuming such a scenario exists, then the parent dies. I mean, the father dies. his estate will be distributed strictly in accordance with the Sharia law, the Islamic laws, which is allowed by the Law of Succession Act, including the wife here, unless the Sharia law becomes inconsistent with the laws of Kenya. But you see, one of the customary laws that are strictly adhered to or followed or observed even by the courts of the land, I always call them the Sharia laws, the Islamic laws. Yeah? Because they rain down from their customs, you see. So, including this wife, unless there was divorce and there were terms of divorce and what have you, they had parted ways, all those things. But you see, even at divorce, our law requires that the divorcee is also considered in the inheritance unless she has remarried. So, the father's estate will be inherited in accordance with the Sharia law. The mother's estate, if she dies, will be dealt with in accordance with the Kenyan Christian laws. I know our laws are largely Christian.
Back to the Sharia laws, under what circumstances would the court look at this and say, we won't use the Sharia law, let's go with the Kenyan Christian laws?
Well, number one is when the issue cuts across. And number two is when there's an appeal from the Qadhi's courts. Even then, shall the court, based on the pact between Kenya and Zanzibar, allowing their courts to operate alongside the Kenyan mainstream courts. Then will the laws seriously scrutinize? The judge or the magistrate will have to seriously scrutinize the Sharia law and properly detail its inconsistency. For instance, if Sharia law dictates that's an example I'm giving, that by this woman leaving her husband, she has become a kafir, and therefore is liable for stoning. And then the woman is condemned for stoning. The mainstream law will come into play. Human rights drums will beat, and the Sharia law will be disregarded in this.
The right to life and
the right to life and the constitutional hierarchy of rights will have to come into play. And so these are some of the scenarios that will have to come. And remember, I was giving that as an example. I am a Christian, I do not know Sharia laws, but I was just giving a scenario in regards to your questions, not meant to provoke, or you understand?
Right. Let's focus on, and still, because they've given us this whole analogy, all that. But then now, are there instances where this child can also inherit? So apart from inheriting the parents, the deceased parents' property, can also inherit the grandparents' property. And we've seen this even in the mainstream media. A good example, former President Moi, and even the grandchildren are really pushing for inheritance of some of the property. How does this play when it comes to now you also involve, let alone the child as well as the parent, but also now to the grandchild?
The law of succession is the law of dependency. You prove that your grandfather prior or immediately prior to his death was providing for you, or you were dependent on your grandfather.
What if you're not born at that time?
If you're not born at that time, of course, natural justice, we will just consider if all grandchildren are receiving something, let all grandchildren receive. But if the members of the family prove that Silas, though being a legitimate grandchild of our grandpa, was not immediately prior to his death being maintained and was not depending on the grandfather, then the law can exclude you. Similar, the reverse also operates. You are the grandchild here, and your grandfather was depending on you immediately prior to your death.
Right.
Your grandfather is a dependent as per law and should be given a share of your estate.
Interesting.
Yeah, that is the Law of Succession Act. You read section 29B of that law. Because in the hierarchy or degree of dependency, it starts with wives, former wives, and children. This one, whether or not being maintained by the deceased prior to his death. Then, B, it now comes to the second degree of consanguinity, where we talk about grandchildren, grandparents, parents, but at section B, you must prove dependence.
Right.
The key term there is proving dependence.
Yeah.
If you cannot prove dependence, the law will disqualify you from inheritance.
Right. Okay, we have about 4 minutes to wrap it up. First of all, before I get your final thoughts, because we've seen some of these acts being revised again, and we're living in different times before they were implemented. Do you foresee some of these acts being, or rather, do you have a feeling that they should actually again be revised? What maybe the Law of Succession Act states that they should look at some of these clauses and maybe revise and just tweak them because of how things are really changing. Case in point, the Court of Appeal November, just that whole proclamation of children born out of wedlock should also inherit. And well, this was a huge conversation. Do you foresee some of these things, and should they actually be there?
When the law made that proclamation, the court made that proclamation, it was already in law.
Okay.
Yeah. So the appeal could only succeed based on not on jurisprudential argument, but on a legal argument. So the legal argument here was that Section 3 interprets a child like this. This child has been denied. They should. Then the court makes that decision based on the law. And then because we were really not much informed on law, we try to make it a camera issue. You see? Now, you see, Stanley, the development of law is based on the societal needs.
Right.
Remember on the serious question on the LGBTQ that came up between President Obama then and the former President Uhuru Muigai Kenyatta. He said that this was an issue for the Kenyan society at that time, you see? And therefore, when the society will come to a realization maybe of a double inheritance here, and they really need to cut on too much unnecessary wealth, where this child inherits from the non-biological parent and somehow gets to know where the biological parent is, and realizes that biological parent also passed on, and the biological parent has some huge estate, and by Section 29A, as a biological child, you are not supposed to prove dependence. That child is automatically a dependent of the biological father, and then he inherits from there, comes to the non-biological parent, also inherits from here. I believe there will come a time when the society will say, there are a group of people in the society who are irregularly enriching themselves, right, and so we need to enact a law prohibiting this. But before it becomes something out of the blues, or out of the moon, then as the law as presently constituted, right, is that non-biological children are also children and should inherit from their non-biological parents' estates.
Okili, allow me to take that as your final thoughts.
Thank you.
Even as an advice to people, because you've really given us some wise nuggets out here, because time is not really on our side. Final comment, remember you can always converse with us on our socials, Jimmy Onjigi, unless Mtwali Ali, okay. I think you really have to filter some of this. You can always go back there on our Facebook page and continue that whole vote. Quite a number of about 1,000 votes on the yes, 249 votes on the no. I don't know, 130 votes. The question was, should children born outside of a marriage union inherit property of their children? You've got some interesting advice. Kindly check them. And in case you have any questions, reach out to Wakili. Utatupatia number as we wrap it up?
Yeah, sure.
Okay.
Our numbers are 0717653746, or you can just go to our website, www.akirolaw.com. You'll get everything there.
Fantastic.
Thank you.
I hope you've saved that number. And even as you save it, putting your phone kando, look for your sporting attire, some gym attire and all that, because we're getting into all that after this short break, getting into a full body kind of physical workout. Stick around.